All right, good morning. My name is Ferris Maselli. I'm here at the NT House Hub to speak to you all about startup legal issues. So, quick introduction about myself and my background. So, I am managing partner at Lloyd Maselli, LLC. We're a law firm with offices both in San Francisco and in Texas. I was previously senior counsel at Apple here in the Bay Area. I was a senior product attorney for special projects, most notably for the Apple Watch and a bunch of supply chain components at Apple. Before that, I was at Dell in Austin, Texas, where I oversaw the software and peripherals business, a $10 billion business for Dell. And before that, I was an associate attorney at DLA Piper in their intellectual property section, as well as doing patent litigation. In terms of just my education, I went to UT Law in Austin, Texas. I've got a master's in computer science engineering and undergrads in biomedical engineering and computer science as well. So I feel like I'm very well positioned to understand technology and engineering issues and represent companies such as yours in intellectual property issues. So let's talk about formation issues. So the choice of entity that you have for your startup is the most important decision that you make very early on. You should always be conducting business under an entity. You want to limit your liability personally, and to be able to get any type of funding, any type of contracts, you're in a much better position to have an entity doing those negotiations or forming those contracts. There are a number of issues that will arise that will determine the costs related to your formation. Mainly you'll end up seeing the number of members or partners or shareholders that you have will always end up increasing the complexity of the formation costs, as well as the bylaws, etc., and coming to terms on how you want to end up structuring and dividing the equity in the entity that you set up. Obviously, the more money that you're looking to have invested, you'll also have additional precautions included within those bylaws of the corporation or the LLC or whatever it is that you set up. And obviously, your choice in whether to go with a big law firm or a boutique law firm will also significantly impact the costs that you'll end up seeing spelled out here during our presentation. When you're making a decision related to who to hire as a lawyer or a law firm, ask your friends, ask other founders. They're bound to have suggestions and recommendations for people that they've had positive and not so positive experiences with. Make sure to talk to other attorneys to see if you can get recommendations. And usually the last step that you want to take is to interview 2 or 3 law firms. It's important to realize that no matter what the actual name of the law firm is, and having thousands of lawyers may sound very, very attractive and prestigious, it's a concern about who you're actually going to be working with. So you want to make sure that you're interviewing the actual attorney and that you feel comfortable knowing that this person is your first partner in the business who will serve as an advisor, and you want to make sure that you're very comfortable in being able to explain exactly where you're at and where you're planning on going with your business. So here you'll see the various costs associated with the different types of entities. Typically we end up recommending LLCs as an entity that's just the simplest to form with the least paperwork and reporting requirements. But if you're actually looking at raising capital from VCs and giving out equity in your company, then most likely you're going to have to end up setting up a formal corporation. There's all kinds of debates on the best states to end up forming your entity in. And again, if you're going to be looking at having outside investors and VCs come in, you're going to want to end up looking at Delaware The only reason that Delaware is so attractive is because they have courts that are specialized in only business law. So you're not going to have a judge that's listening to a divorce case or other civil matter and then listening to a business dispute between founders. So that Court of Chancery in Delaware is specialized, and it's become recognized, that they have a developed body of law related to corporations, and that's what a lot of investors will demand or require as part of their investments. Other states that are very popular include Nevada and Texas, where you don't have a state income tax, you don't have these franchise tax requirements, so it's a very, very low cost of entry. I'm biased towards Texas because they have an amazing Secretary of State's website, and the ability to file everything online is extremely, extremely automated. They're very business friendly. A couple of other concerns relate to your tax EIN number, which is basically your social security number for your business. That's something that you'll typically have awarded after you've applied for certification from the Secretary of State. You end up applying to the IRS for a number that you end up associating with your corporation. And that tax EIN number is required to be able to open up bank accounts and other financing vehicles in your entity's name. So with that, the documentation that you typically want to end up receiving as part of your formation depends on the type of entity. So LLCs will usually have a company agreement, and the cost of that agreement is usually included within that registration price that is often quoted. The same with your bylaws for your corporation. Obviously, the more customized your requirements or the clauses that you're looking to have, the higher the cost that will be associated with that. The other getting started documents that you typically want to end up looking at as a corporation are your master service agreements or your master licensing agreements, master purchase agreements, etc. that you have in place that dictate your terms with your customers, your clients, and those will typically cost around $1,000, just again depending on the complexity there. If you're an online provider, you're going to want to have terms of service or terms of use tied to either your app or to your website, whatever service as a platform or a cloud offering, along with privacy policies. Those are some of the initial starter agreements that you really, really need to have in place as a startup. And finally, you've got your costs associated with insurance and state and local taxes and registration, depending on the type of business that you're engaged in. All right, we're going to turn to financing because that's literally the million-dollar question for a lot of these startups. A lot of your financing will depend on the source of your funds that you're receiving. Most folks that have startups self-fund, right? You've got a bank account, savings, etc. that you've got, and that's the way that you end up initially bootstrapping your company, your startup. Eventually you end up moving on to friends, family, and then other maybe non-related investors. So typically the metric that we use is that it costs about 2 to 5% of the amount that you're raising in terms of legal fees and expenses for structuring those agreements. And what you'll see with corporations, usually you have people that are buying stock, right, within your corporation. And those stock purchase agreements will run a minimum of $800, again, depending on the transaction and the size of the investment that you're looking at. What's a really popular vehicle that was pioneered here in Silicon Valley are these SAFE agreements. That's a standard agreement for future equity. These are terms that are fairly standard templates that minimize any kind of negotiation that's required in terms of, they're not being too investor friendly or too startup friendly. They're fairly middle of the road and allow you to invest with a fairly high level of confidence, knowing that in the future, whatever other financing events that take place, you will have a stake within that startup or corporation. Within LLCs, you usually look at purchase agreements. You can also have safes related to LLCs. And then the final type of financing that you usually end up seeing for startups is debt, which is basically, just as it sounds, it's a loan that is usually interest-bearing and has specific terms related to start and end dates, and provisions related to collection. So these are the typical costs associated with each of these different types of financing for your startup. So moving on to building your startup, it's obviously all about the talent, right? You can't create intellectual property without the people that are creating that intellectual property. So let's talk for a few minutes about the different ways and methods of which you can end up building your team. The initial question is always hiring versus going with an independent contractor. And both of these have their benefits and costs associated with them. An employee relationship is a much more formal relationship with a lot of laws and compliance requirements that end up dictating that relationship. And you'll see that when you're choosing which route to go, it'll also depend on how early stage you are. My personal recommendation is to rely on independent contractors early on, so you don't have these additional filing and compliance requirements that come along with hiring a formal employee. Obviously, both agreements are super important to have a number of provisions related to your relationship. You'll end up seeing that non-compete clauses are very popular, the enforceability of which will vary from state to state, along with the actual terms, right? You don't want something that's too onerous. Precluding someone from being employed for the next 5 years within the technology space is way too broad and doesn't end up serving your actual objective there. It's really important to carve very, very specific clauses related to non-competes so that in the event they're challenged, they're actually seen as fairly reasonable and enforceable. Non-solicitation is also really important. You don't want a person who's leaving your team to end up soliciting the talent from your team that you've worked so hard to end up putting together. Confidentiality and non-disclosure agreements and clauses are absolutely critical, especially for early stage startups, and the idea that it's a race, especially if you're in a fairly unknown or untrodden area or technology. Not having a team member be able to go and disclose your customer list, right, or your supplier list and costs and product roadmap is really, really important. So those confidentiality agreements, we usually recommend that you have on the front end, even before hiring an employee or an independent contractor, to have a standing non-disclosure agreement. And these things are not one size fits all. There are a number of variances between NDAs that are important to understand. Most notably, whether it's unilateral or bidirectional, right? Depending on the relationship, if you're doing a joint development, you want to be able to exchange information both ways, as opposed to an employee or a contractor relationship where you're providing them information and they have a unilateral responsibility to keep that information confidential. The other super important clause relates to your IP assignment for all of the work product that these employees or contractors are creating for your company. Without this IP assignment clause in your contracts, it is unknown who ends up owning that intellectual property, whether it's software that they've coded, whether it is some invention, even writing, right? If they've produced marketing materials for you or graphic designs for your advertising campaigns, if you don't have work for hire clauses that end up assigning the intellectual property in the product that they're creating to your company, you will have legal issues down the road in determining the ownership for those pieces. Let's move on. So, one of the last considerations in this kind of employee relationship, and this is one of those things that ends up tilting in favor of independent contractors, in our opinion, relates to the compliance issues. So these are just some of the laws that end up applying to your employee-employer relationship, whether they're Equal Pay Act, ERISA, FICA, unemployment compensation, the benefits, you name it. All of these things are sidestepped when you end up going with an independent contractor relationship. Obviously, the downside is an independent contractor is an independent contractor. You cannot dictate hours that they end up working. You cannot dictate their micro level direction on their work. So meaning you can provide broad guidance for an independent contractor, but the closer you get to actually managing their product and providing them with resources for their development, the closer it is to being seen as an employee relationship, and that can have all kinds of ramifications for your business in terms of liability for having insurance and workers' comp and the like. We've provided a couple of useful employment law sites for you to be able to reference and pull up additional information related to your laws that you have to comply with. The other thing is, once you end up getting to beyond 5 employees, you really want to have an employee handbook in place to be able to have very strict guidelines related to all types of workplace issues, so you have an easier time with a termination and it's seen as a justified termination as opposed to something that may raise flags down the line. It is critical to always remember the basic mantra, contract before work or money. Do not have anyone perform any work for your company without having a contract in place. Again, whether it is an employee contract or an independent contractor agreement, it will save you all types of headache down the line, especially in understanding that intellectual property consideration that we discussed earlier. If that contractor or employee has any issues with the contract terms, it's better to know up front that that's going to pose an issue and solve and hopefully avoid a world of pain on the back end, especially at the cost of litigation that you end up incurring if there is a dispute. All right, so the final topic that I wanted to cover in this morning's presentation relates to intellectual property. And this is a hallmark of all of the startups and technology companies here in the Bay, and especially has much more broader implications even outside the technology sphere as well. So what is intellectual property? A lot of people will hear this term and throw it out fairly often without really understanding what it encompasses. And intellectual property is by definition very broad. It's not something that you can characterize within some of the forms that it ends up taking. But the idea is that if you've created an original work, a design, a painting, a song, a melody, software, you should have the right. So let's turn to what is intellectual property. A lot of people use the term intellectual property without truly understanding what it encompasses. And to be honest, it is a very, very broad concept. It includes everything from patents, trademarks, copyrights, trade secrets, trade dress, personality rights and publicity rights and the like. It's a very broad concept in the idea that if something creative has been fixed in some form or method, whether it's a painting, whether it's the design of a building, right, and with particular architecture, whether it's the design of a Coke bottle in that classic wasp shape, all of these are forms of intellectual property. And the paradigm that we exist in related to the intellectual property system is this idea that we want to be able to encourage creative folks to innovate, to invest the money required into research and development, and be able to actually obtain some of the rewards, right, from that investment and that time. Imagine if an artist never got compensated for the songs that they'd performed and written. The same concept applies across all different types of intellectual property. If you've written a play, if you've written some software or painted a painting, all of those things should be protected to provide some form of compensation for the owner. And the laws that relate to that will vary widely. Even at the state level, you'll end up seeing protections federal level and then internationally, obviously. So let's talk about the different types of intellectual property. The three types that people are most familiar with include patents, which cover inventions, methods, processes, compositions, compounds, chemicals, a wide range of inventions. And the basic standards that they end up using to determine whether something is in fact patentable is whether it's new, whether it's useful or has utility, and whether it is non-obvious. The non-obviousness is the most difficult standard to explain to a lot of folks because it's a standard related to what they call faceta, person having ordinary skill in the art. So it has to be non-obvious to someone who's actually practicing regularly within that particular space, not non-obvious to a layman off the streets. That's the legal standard that's usually applied within the US Patent and Trademark Office for determining whether something is in fact patentable. A trademark, people are very familiar with because of all of the marketing and advertising associated with these big brands. So when you think of the Apple icon or the Coca-Cola cursive font, you immediately recognize the source of those goods and services. Trademarks not only protect the name of the company, but they also protect the names of the products and services. So when you think MacBook, when you think Camry or Honda Accord, these are all names of the products in addition to the name of the company. You also have services that are covered under that concept of trademarks, as well as slogans. So when you end up thinking about McDonald's and the slogans that they have for I'm completely blanking on what the McDonald's. Yeah, I'm loving it, right? Thanks to some of the audience members for being able to mouth that out to me. But there's a number of slogans that you want to be able to trademark and have people hear. When you hear "think different," you immediately end up associating that with a particular source for those products, right? That's the Apple "Just Do It," another classic example of a slogan that immediately triggers an association with the Nike brand. So those are really, really critical for you to be able to build brand loyalty for your company. And it's absolutely critical to do this at the very earliest possible stage that you can. As soon as you know a particular name for your company or a product, it is critical to do a search and have a clearance conducted to ensure that you can actually use that name in the way that you intend on using it. I can't tell you the number of times that we've had companies come to us after they've received a cease and desist letter, maybe 10 months, a year, whatever it is down the line from when they've started using it. And it is incredibly expensive to rebrand, to have to recall materials and promotional marketing pieces that have that infringing name on it. So save yourself all of the headache and the amount of pain in just clearing a trademark and making sure to register it on the front end. The final type of intellectual property we're going to talk about here is copyright. People hear the term copyright a lot, and it's often misused, thinking that, hey, it only ends up applying to film or to music. But you can end up absolutely copywriting almost anything that you end up fixing in a tangible medium that has a level of creativity or originality that's tied to it. So a lot of folks don't recognize that their marketing brochures, that they've spent a lot of time and effort in developing and laying out. If you are concerned with a competitor copying your materials, it's absolutely something that you should go ahead and copyright, and make sure that you register that copyright with the Copyright Office so you have all of the benefits. You have that Circle C, you have the ability to send a cease and desist letter to another infringer or a competitor. It's amazing how you can end up pulling things down from online marketplaces like Amazon or eBay by quoting copyright infringement as well on some of the material that people are using to resell products that are similar to yours as well. So I'll leave you with those three types. We'll move on here. So let's talk about the costs that are typically associated with intellectual property. So in covering the three types that we discussed earlier, patents is the most prominent, especially within the technology sphere. Patents have three distinct types that you can end up applying for. The first being a utility patent, and that is broken up into two different types of applications. You have a provisional application and you have a non-provisional application. A provisional application, as the name implies, is a placeholder. It's a line in the sand that ends up establishing your priority date. A priority date is super critical in the US and the rest of the world now, since they've all harmonized on a first to file system. So regardless of who actually invents something first, it doesn't matter. The first person to have an application describing the technology or the innovation on file with the respective patent office is the priority owner. So a provisional patent basically grants you 1 year to end up filing or converting to a non-provisional application. Provisionals are very popular with our startups, especially those that are bootstrapping, given the fact that the cost is anywhere from 1/3 to half the price of a non-provisional patent application. So you'll see that within that year, you have to end up converting to a non-provisional, or else you've abandoned your rights to that claim for that non-provisional application. The third type of patent application relates to design patents. And a lot of times you'll end up seeing folks want to cover or have protection to the non-functional elements of their inventions or products. So another kind of classic example of that is the design patent on the Coca-Cola bottle, right? That wasp shape is very distinct and has a design patent associated with it. You can also think of other products, clogs, right? And other distinctive shapes, right? But the important thing is to recognize the distinction between a utility patent, where you're actually patenting or protecting the functionality of the invention, as opposed to the non-functional design elements. Trademarks. We've talked about how they can end up covering the business name, the products, the services, and slogans. Typically, you end up filing for a U.S. Patent and Trademark Office application that typically costs about $1,000 plus $225 per class. So a trademark is only good to protect a class of goods or services. And this is the reason why we can have a trademark for Pioneer that covers electronic goods, and Pioneer for sand and other building materials. You can have two companies that exist with the same exact name, but because they're operating in completely different spaces and unrelated classes, they can coexist. You also have state trademark registrations, which I also recommend as a quick and dirty way to have some protection in place, since a federal trademark usually takes at least 3 months before they'll even examine it. Let's turn to copyrights real quick. The basic fees, attorney fees that you end up looking at, are about $500 per copyright registration, with a filing fee of anywhere from $35 to $65, depending on the size of the entity and other considerations. With that, we're going to turn and open it up for questions.
Can you go back to that previous slide, please?
Yeah, absolutely.
So what I'm wondering is, when you have something like a voice assistant, right? Is the voice, would it be a design patent, or would it be something that's covered under copyright?
The voice assistant?
Yeah, so the actual voice, how the voice sounds, is not the functional aspect, it's just the design.
So that's a very interesting question. The voice wouldn't have any kind of utility on its own, so it wouldn't qualify for a patent. You could potentially apply for a trademark if that voice is associated with a particular source of a good or service. So the closest parallel that I can think of is Harley-Davidson. So Harley-Davidson has actually trademarked the distinctive exhaust sound that they have, because it's particularly associated, right? You hear that sound, you hear that revving, and you immediately recognize that that's a Harley-Davidson. They've been successful in actually trademarking that as a source. It would be very difficult to identify one particular voice for a voice assistant, other than maybe Siri. I mean, that's one of those that is very, very distinctive and immediately recognizable, at least in the default setting. So that's the best that I have there. Obviously, if you have particular recordings of that voice, that's a copyright, right? That's a recording that you could end up protecting, so no one can use that exact same voice with those particular sounds.